Will I need to notify my mortgage lender if I transfer my real estate into a revocable trust or an irrevocable trust? What they're really asking when they ask this question is it going to trigger the due on sale clause, right? Every mortgage, it has a due on sale clause where if you transfer the property to someone else, it immediately accelerates the loan. You have to pay it back. That's why when you sell your property, if you have a mortgage on it, at closing, you have to pay off the mortgage first, right? They don't let you just sell it and then walk away from it. That's part of the obligation. However, there are situations where you can change the title of the property and not trigger that due on sale clause. And that really is the subject of this video. And it's what's covered in a law called the Garn Saint Germain Act. That is a federal law, so this applies across all 50 states. And essentially there are certain situations where you can change the title of the property and it will not trigger that due on sale clause. The mortgage lender cannot get upset. One of a very common scenario is if you are with an estate planning attorney. If you're in Florida, hopefully that's with elder needs law. But we are often working with people who own a home and they want to transfer into a revocable trust. Sometimes it's going into an irrevocable trust. In either situation, if the owner maintains the full and unrestricted right to live in that property for the rest of their life, it will not trigger the due on sale clause. They remain what's called the beneficial owner, and therefore the loan is not accelerated. There are a couple of other situations where the Garn Saint Germain Act applies as well, and that is if, for example, if you're adding a spouse or a child, if you're transferring the property to a spouse or a child, or a partial interest in the property to a spouse or a child, it also will not trigger the due on sale clause. So people own property, they get married, they want to add their significant other, now spouse, to the deed, not a problem. We often utilize a tool called a ladybird deed. It's a way to transfer property to someone else after you pass away. If we're naming a spouse or children as the people to inherit the house in that ladybird deed, it will not trigger the due on sale clause as well. In addition, if you need to get a second mortgage on the property, that will not trigger the due on sale clause. There are a couple of other exceptions to this Garn Saint Germain Act, but second mortgage is a big one. However, it does not apply to a reverse mortgage. That is a special carve out and kind of an exception to the exception, right? If you get a reverse mortgage, that can trigger the due on sale clause, but a second mortgage will not. So that is it in a nutshell. There is significantly more to it than that, but these are some of the more common scenarios that we see people worried about as to whether or not they need to call their bank. Certainly, it is a good idea if you're going to transfer title to let the bank know and make sure that they don't interpret the Garn Saint Germain Act any differently. But broadly speaking, transferring property into your revocable trust or an irrevocable trust, if you retain the right to live there, which is kind of the scenario that we see most often, or dealing with ladybird deeds, if it's going to children or a spouse, there is never going to be an issue. There, again, more to it than that. If you want to talk more about the Garn Saint Germain Act or want to talk about estate planning, Medicaid planning, or probate at all, we serve the entire state of Florida. I hope you found this video informative. If you have, please like it, please share it, and we're trying to get good information out there. Thank you very much for watching.